politics, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government.
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy. I'm Michael Baranowski, a political scientist at Northern Kentucky University. My guest today is Eric Posner, the Kirkland and Ellis Distinguished Service Professor of Law at the University of Chicago. I've been following his work for quite a while now, and back in 2018, I actually had the opportunity to talk with his co-author, Glenn Weil, on the podcast about their book, Radical Markets. Today, Professor Posner and I discuss his latest book, How Antitrust Failed Workers. Eric Posner, welcome to the show.
Thank you. Nice to be here.
So I thought what would maybe make the most sense would be to start off by not talking about labor markets, which is the focus of your book, but actually about product markets. Because as you point out really throughout the book, product markets and allegations of monopolistic practices in those markets, well, those have gotten a lot more attention than issues that you're highlighting involving labor and wages. So to start with, can you explain what constitutes a monopoly and why monopolies are usually thought to be fairly undesirable?
So when we talk about product markets, we mean markets for the sales of goods and services like automobiles, or today, using Google's search engine or Facebook's interface. And a monopoly literally means that a single firm sells all the goods and services in a particular market. So back in the 19th century, if you wanted to buy oil, you bought it from Standard Oil. Today, if you want to use a search engine, you'll use Google's search engine. In practice, we use the term monopoly a little bit more loosely than referring to 100% of the market. We generally just mean a very large fraction of the market, 90%, 80%. Something like that. A famous monopolist was Microsoft, and I think still is to some extent. If you own a non-Apple PC, you almost certainly will have to use Microsoft's operating system. Monopolies are generally thought to be undesirable because they can charge a higher price than what would prevail in a competitive market. So if you take something like automobiles, if there's just a single car manufacturer, people have no other option if they want to buy a car except to use that manufacturer. So the manufacturer can charge a very high price. If there's competition in the automobile industry, the car manufacturers will bid each other down in order to obtain more buyers. And not only reduces prices, but of course increases output. More people get cars, they pay less. That's good for the economy. And let me just add one other point, which is in antitrust law, we're concerned not just about monopolies, but also cartels. And the cartel just means a small number of large firms. So let's say the airline industry has basically four big firms, the domestic airline industry. And that's also sometimes called an oligopoly. And if the four airlines got together and agreed to fix prices, then they would form a cartel, which is also illegal. And for the same reason that monopolies are undesirable, which is that they can raise prices and reduce output, causing harm to society generally. I should also add, by the way, that while cartels are illegal, flat out illegal, monopolies are not illegal if they're obtained through innovation or just out competing everybody else. A monopolist engages in illegal behavior only if it takes certain types of competitive action, anti-competitive actions that prevent other people from entering into the market, so that it loses its monopoly. So if it maintains its monopoly in certain illegal ways, then it can pay a penalty.
when I think about monopolies and antitrust and all the things you mentioned, two pieces of legislation stand out in my mind: the Sherman Act of 1890 and the Clayton Act of 1914. And I thought maybe you could talk a little bit about the importance of those pieces of legislation and just sort of broadly what these laws prohibit, what sort of practices they prohibit.
The Sherman Act is the original antitrust statute in the United States. And it's actually called antitrust because at the time monopolies used the trust form, the legal form of a trust in order to, in order to structure themselves for various reasons. So the Sherman Act is really the essential original law that everybody refers to. Ironically, it wasn't really enforced in the first 10 years or so of its existence. The courts gutted it using fairly aggressive interpretations. And so only when Teddy Roosevelt entered office and later Taft and Woodrow Wilson did the Sherman Act really get enforced the way it was supposed to be against monopolists. Interestingly, early on, the main successes that people had using the Sherman Act was against unions rather than large corporations. The Clayton Act, enacted under Wilson, along with the FTC Act of 1914, was basically just designed to strengthen the antitrust laws. And various other statutes since then have been enacted, which have incrementally strengthened the antitrust laws. But the basic structure of antitrust law can be traced back to the Sherman Act. And very broadly, there are two main sections of the Sherman Act, Section 1 and Section 2. Section 1 makes any kind of restraint of trade illegal, and that's basically been interpreted to mean something like a cartel, a couple firms getting together, entering into an agreement to fix prices or to, create a monopoly. Section 2 is focused on monopolies. And basically, it makes it illegal for an existing monopoly to engage in actions that strengthen or extend or maintain its monopoly. It also makes it illegal for firms to create monopolies in the first place if they don't do so in normal ways, like through innovation and regular market activity.
And so I think this is where maybe we can come into the idea of monopsony. It sometimes doesn't flow trippingly off my tongue here, but because, as you point out in the book, this legislation doesn't really distinguish between monopoly and monopsony. And I think this is maybe a point for you to explain to everyone what exactly a monopsony is and why that's sort of thought to be undesirable.
So a monopsony is just a monopoly in a mirror. So a monopolist sells into a market. It's a seller. There's a single seller who sells goods or services to multiple consumers or other buyers. A monopsonist is a single buyer who buys from multiple sellers. Now, monopsony can refer to goods and services, or it can refer to labor. But consider, for example, Walmart. Some people say that Walmart is a monopsonist or something close to a monopsonist. It's a huge buyer. And so the people who sell to Walmart, the suppliers, they're facing, effectively one very large buyer. And Walmart can use its market power against the buyers to suppress the prices that they pay below the competitive rate. And although that sounds good, it's actually bad, because if the suppliers are being forced to accept lower than the competitive rate, they'll produce less output, which means less economic growth and higher prices. Walmart will do well, as monopolists and monopsonists always do. They'll make high profits, but there'll be fewer sales ultimately to consumers. Now, a labor monopsony is just a monopsony where the sellers are people selling their labor rather than firms selling goods and services. And the same idea applies. So the employer is buying labor from its workers, And if there's just a single employer in a market, let's say in a town, there's just a single employer, the employer can offer wages that are below what the competitive wage, which is usually thought to be the amount that you have to pay a worker that's equal to how much the worker actually contributes in value to the employer. And if you suppress wages below that amount, then some people will not work. They'll stay out of the workforce. They might take other jobs that they're not as suitable for. And so this results in not only lower wages, but less economic output. So it's a problem both for equality, in the sense that labor monopsony should lead to higher inequality between people who live through wages and people who live off investments, but it also will reduce economic output and economic growth. It's really a very similar concept, and economists have, understood that monopsony is just as bad as monopoly, since Adam Smith, who wrote about employer monopsonies.
This is probably an oversimplification, but at least in terms of first order effects, it seems like monopsonies tend to actually help consumers, at least initially, by lowering prices, whereas monopolies tend to hurt consumers in terms of prices. And I know that issue of kind of consumer harm and prices, that's kind of a contentious issue in antitrust, how we interpret harm and so forth. But is that kind of a rough distinction that we can make between sort of the primary targets, or is that just too oversimplistic or too broad?
Yeah, it's not accurate, and this is very common misconception people have. So it's important to be clear about it. So yes, the first order effect of a monopoly is to raise prices for consumers. The first order effect of a monopsony is to reduce wages. Okay, and of course, people are both workers and consumers. So there's a first order harm to ordinary people in both cases. If prices are high, that's bad. If your wages are low, that's bad. It's bad from a social standpoint. But it's not true that monopsony will result in lower prices in an immediate sense. And the reason is that if an employer is paying its workers less, it hires fewer workers. And if fewer workers are hired, then the employer's output will be lower. And then this is just your supply and demand curve. If output is lower, then prices are going to be higher. Now it's a little bit more complicated than that, because if the employer faces competition in the product market, it will sell less, but other firms may make up the difference, like foreign firms that don't have monopsony power. They'll just increase their output. So ultimately, a consumer might not be affected at all, or the consumer might be affected a little bit or a lot. It all depends on the market structure on the product side. But there's no doubt that from just kind of a standard simple economic framework or social welfare framework, that the first order impact of monopsony is to reduce the well-being of people. Generally, there's no offsetting benefit except to the shareholders. The shareholders make higher profits, which is true in the case of monopoly as well. But those benefits are less than the costs to consumers and workers.
Yeah, I'm glad you explained that, because I think, as you pointed out, that is sort of a common misconception. And kind of moving on from that, I want to talk about measurement issues, because this is, as you go into in length in the book, this can really be difficult. I think we all get a sense of how you measure monopoly power. You can look at the percentage of searches done, say, from Google or Bing or something like that, and get a sense of that. But measuring monopsony or labor market concentration, it seems to me to be a less straightforward concept. Is that fair to say?
Yeah, I think that's fair to say, although I think partly what's going on here is that economists have been figuring out ways to measure market power and product markets, for really a century or more. And so a kind of consensus has emerged about how to do that, whereas economists have not really been focused on labor market concentration. And so, people who are writing about labor market concentration today are drawing on what economists have done for product markets, but it's a work in progress. But just to explain, how this is done, in the product market side, there are kind of, two basic ways of measuring market power. And so market power, we mean a monopolist has, a huge amount of market power. It has the power to raise raise prices above what the competitive price would be in a competitive market. If you have a competitive market, nobody has market power. And, market power can be anywhere from, 100% to zero, depending on whether you have a monopoly or a competitive market or something in between. Everything is in between in the real world. And so it's important to have a measurement. And one way to measure things is just to take, let's say, the top 4 firms in the market, identify the 4 biggest firms, and add up their market share. So if you've got, let's say, the 4 biggest firms all have 20% of the market, then you say the top 4 firms have 80%. And if the top 4 firms have only, let's say, 2% of the market, then the top 4 firms have 8%. And so if, the index is 8%, you have a pretty competitive market. If it's 80%, it's a pretty concentrated market. And so the antitrust authorities, the regulators, and the courts will look at that number. And if the number is high, they'll say, okay, there may be a problem here. We have to do further analysis. If the number is low, they say this is not a problem. The other more standard method these days for measuring market concentration is called the Herfindahl-Hirschman index. It's a very similar idea, except you give additional weight when a firm is especially big. So under the Herfindahl-Hirschman index, if you've got a single firm with 80% of the market and a bunch of small firms, the number will be higher than if you have 4 firms with 20% of the market. And that's just because, a single dominant player is really going to have more market power. It's going to be able to suppress prices more than if you have a bunch of large players who can kind of coordinate with each other, but there will be slippage. We turn from, sorry, go ahead.
No, please go ahead.
Yeah. So as we turn from, monopoly to monopsony, people have been using very similar measures, like the Herfindahl-Hirschman index. You could use it. So first you have to define what the market is. And so labor market, this is kind of rough, but basically we look at the distance that people are willing to commute. So this could be, 5 miles, 10 miles, 20 miles, depending on the location. But let's suppose it's a big city. We might say the commuting zone is the big city. And then we have to identify the particular job. So let's suppose the job is accountant. Okay, so we might have in a big city, several thousand people who are accountants. They're trained. They're the sort of people who will be hired by an accounting firm or another firm that needs an accountant. And then we look at the firms that hire accountants. And probably the biggest employers of accountants will be accounting firms. And they'll have a share of the supply of accountants. So it's possible that there could be a single big accounting firm that hires 80%, that employs 80% of the accountants in this market, or there might be no big accounting firm, but lots of companies that need an accountant. In which case, maybe the biggest company only has 2% of the accountants in the area. And then you can use, either the 4-firm concentration ratio or the Herfindahl-Hirschman index to come up with a number. And again, it's basically a percentage from 0 to 100, or the Herfindahl-Hirschman index is actually from 0 to 10,000 for obscure reasons. But basically, the higher the number, the more concentrated. And the reason why these concentration measures are used is that there's empirical evidence that as the number is higher, you get either higher prices in a product market or lower wages in a labor market.
And when we compare those indexes with labor and product markets, it surprised me at least that labor markets are actually, there's a lot more of a problem with that sort of market power and concentration. And that's in part, or in large part, due to the fact that, as you point out, those labor markets tend to be local as opposed to national, right?
Yes, exactly. And, this is a really fascinating, point, maybe from the perspective of the sociology of knowledge. I mean, economists have always known that labor markets can be concentrated, but they always assumed that they were not concentrated. And most economists assumed, if you looked at economics textbooks from not long ago, they would just say labor markets are competitive, unlike many product markets, like airlines or whatever. And I think the reason why is people were just thinking, we live in most economists, live in cities or towns, and there are lots of people around, and so if you work at a McDonald's, there are a lot of fast food places you can work at. And if you're a lawyer, there are a lot of law firms. And so they kind of just assumed that labor markets are competitive. And this all changed when a few papers were posted and now published a couple of years ago that examined all the labor markets in the country in a much more rigorous way. When you think about it, and as you mentioned, these papers found that a huge number of labor markets are incredibly concentrated, far more concentrated than most product markets are. And when you think about it, it's actually not that complicated. A big part of the country is rural, suburban, small towns. In those places, there are not that many employers. And if you have specialized skills, if you're an accountant in a small town or a rural area, there are probably very few employers that will want to hire you. Maybe there's a local Walmart, but the fast food joints aren't going to want to hire you. They don't need an accountant. So you have very few choices. There are very few employers. And even in big cities, a lot of people are very specialized. So if you're a pediatric oncologist, I'm sure that there's some big cities where there are lots of hospitals that are going to employ you, but in smaller towns, there may be, just one realistic employer. And so, yes, it turns out that, a huge fraction of labor markets are extremely highly concentrated.
And, also along with this idea of local labor markets, it seems to me that this affects the incentive structure for bringing these suits. As you point out in the book, product markets tend to be national, and so they're perhaps better targets for attorneys who need resources to bring these suits. But whereas even if you're looking for, triple damages under I believe what Sherman or the Clayton, you would know that's still a fairly small pool, and so it might be difficult to get attorneys to actually take on some of these cases, even if they can certify a class. Is that right?
Yes. So product markets are frequently national. Of course, they're not always national. Like the market for groceries is a local market, although Amazon is kind of changing that a bit. But basically, most consumer goods are national markets. All the goods that you buy on Amazon, they're national markets, automobiles, search engines. And so national markets are good targets for not just private litigators, but the government, the Justice Department and the FTC, which also enforce the antitrust laws. They're bigger targets. There's more at stake. It's kind of easy. It's easier to bring these cases because you're looking at some single big firm that has possibly engaged in anti-competitive behavior. And then in the case of private lawyers, they can create a consumer class consisting of everybody in the country who's bought the product. And so consumer classes can easily have millions or even tens of millions of people. And that means that, even if the actual harm is relatively small, $10, $100, $1,000 per person, you multiply that out through this consumer class, it's a very large number. And so that number will be large enough to cover the costs and risks that private attorneys incur when they bring antitrust cases, which are notoriously expensive and complicated. And when you switch to labor markets, it's not like that at all. Most labor markets are local. You can think of, there are a few that are national, like maybe the market for CEO or certain very highly skilled positions. Most labor markets are local. People don't move just for work usually. They live somewhere and they're going to look for a job within a commuting distance. And that means that a class action brought by a lawyer on behalf of workers who have been the victims of monopsony, the class is going to have maybe a few hundred, a few thousand, 10,000 people in it, something like that. Now the damages per person might be higher because we're talking about someone's salary of $50,000 or $100,000 or $200,000 maybe being reduced by 5 or 10 or 20%, but you still have much lower numbers. So the ultimate award is going to be relatively low, and as a result, there's going to be there's going to be less of an incentive for lawyers to bring these cases. A final point is that a lot of the victims of monopsony are actually low-skilled workers. There's some litigation right now going on against McDonald's and other of the big franchises who employ people in their restaurants at low wages. And, if those wages were suppressed, it's going to be, from the standpoint of a class action lawyer, a relatively small number and possibly not enough to justify litigation.
But even considering that, those incentives or lack of incentives, it was really kind of stunning to me how the gap between claims that are filed based on monopoly or product versus labor market concentration. You mentioned at one point, and I like triple underlined this when I was reading the book, that in your research you weren't able to locate a single monopsony claim under Section 2 of the Sherman Act that made it past the summary judgment stage, and that just kind of stopped me in my tracks. And I thought that's worthy of discussing, because there are a lot of reasons you talk about why that is the case and how why courts sort of dismiss these things literally. And so why is it, what do you see the main reasons as making the case that there is illegal wage collusion going on here?
Right. And just to be clear, so in that sentence, I was referring to a case against, analogous to the Microsoft case or the Standard Oil case, where you have a single employer. There's been a little bit more success under Section 1 against which alleges collusion. For example, I'm sure you're familiar with the NCAA cases. There have been a bunch of cases against sports leagues, which have been, more or less successful. And there have been a few others involving mergers and no poaching in the high-tech industry and so forth. But yes, the bottom line is no successful Section 2 cases and a very small number of successful Section 1 cases, whereas, every year there are hundreds of, reasonably successful product market cases. So what's the reason for that? I think, the odd thing is, I think a big part of the reason is simply that people didn't realize that labor markets are often subject to collusion, that they're often not competitive, which is actually bizarre when you think about it. In The Wealth of Nations, Adam Smith talks about employer collusion, and he says it happens all the time, but no one ever talks about it. And he literally says that, and he says, in fact, the workers usually, they grumble, but they can't do anything about it. And whereas people, and he was also saying, people get really angry when workers in the 18th century, when workers unionize, form, the equivalent of a union, but they don't seem to care or notice when employers do the same thing. Why is that? And, maybe that employers are more powerful, more sophisticated, more subtle. But I think, part of the reason is that there's just this ideological gap. Just in antitrust law depends very heavily on the understanding of economists, and economists just didn't think about this. Another key part of the explanation is that in the old days, unions were important in trying in consolidating or aggregating the market power of workers to oppose the monopsony power of employers. And I think for a long time, people just thought, well, that's what unions do. We don't need antitrust law for it. That may well have been true, but unions have been declining over the last, half century or more. To the extent that unions were able to oppose labor monopsony, they no longer can. And then, there's just something about the law. There's a lot of path dependency in the law. The more antitrust cases or cases of any kind that are brought, the easier it is to bring those cases in the future. Everybody knows the rules. When plaintiffs, lawyers threaten, or the Justice Department threatens to sue antitrust violators, the violators will settle if they know that they've violated the law usually. And if not, the case will proceed. There have been so few, although there was a Supreme Court case in the 1920s that recognized an employer wage fixing claim. They just, never got started. And I think part of it is, as I said before, because of this general understanding, few cases were brought. And then on top of that, because so few cases are brought, people don't know what the rules are, and that adds to the risk and cost of litigators, so that they'll be even more reluctant to bring these cases. The problem, of course, is that if your CEO firms, if the firms are rational profit maximizers, as economists assume, and they know that if they engage in product side anti-competitive behavior, there's a good chance they'll be sued. Whereas if they engage in labor side anti-competitive behavior, there's effectively no chance that they're going to be sued. They're basically going to orient their anti-competitive behavior to labor markets rather than product markets. And so, there could be a very serious problem here as a result of this lapse in antitrust enforcement.
But it also seems to me that there are what I might call measurement issues involved in making these claims about labor market driving down those prices, because even if we have access to salary data, which oftentimes we don't, which we do with products for the most part, there are so many things that an employer can argue go into compensation, right? It's not just the bottom line wage, but benefits, healthcare, other things, even more intangible things like commute length, or if you can work from home, workplace culture stuff. These things have real value, but it's awful tough to kind of compare them. And so I was wondering, how much of a problem do you think those sort of measurement issues are when attempting to argue that employers are essentially artificially driving down compensation?
It's definitely a problem. I'm not sure it's a problem that has prevented the emergence of labor antitrust cases. It's like, we haven't even gotten that far, and typically settle, if you can make it like a reasonable case. I think it will be more of a problem in the future as more of these cases are brought. Now, to some extent, there's a similar problem for product markets. If a particular product, as the economists say, the substitutes are not perfect, then you have similar considerations. So as an example, you could have different cars at different prices, but some are low quality and some are high quality. And in order to award damages, you're going to have to adjust for quality, so that you're comparing apples to apples. Now, for some products, that's really easy because they're identical. Like if there was a case, against, light bulb manufacturers or something like that, all light bulbs are basically the same. But, there are other types of products where there's subtle variations. Insurance policies, for example, insurance companies might have different kinds of service, or think of just like a search engine. What's the difference between Bing and Google? Google's maybe slightly better, a lot better. So if if Microsoft, which operates Bing, and Google entered into a cartel, you kind of have to figure out that stuff as well. You'd have to have the quality adjusted. You'd have to have the quality. In fact, a lot of what's interesting in a lot of the tech litigation is that Facebook, for example, gives away its interface for free to consumers, and so you could argue, like, what's your antitrust claim if the price is zero? A lot of people think, of course, that Facebook has a monopoly, including the FTC. But, how could you sue for damages? Well, the argument is, well, people are getting bombarded with ads that they don't like. Their data is being taken from them in ways that they don't approve of. You can think of that as low quality. And if a successful antitrust claim brought by consumers against Facebook ever takes place, those sorts of issues are going to have to be addressed. I mean, the law can deal with these things. It does make everything a lot more complicated and risky. So I do think these complications do play some role in deterring litigators from bringing antitrust labor cases, but probably just at the margin.
Another issue, it seems to me, is earlier you talked about, the market for, say, local market for, say, accountants or doctors. But as you pointed out with the doctors, doctor isn't just a job, a generic job. There are all sorts of, subspecialties and things like that, because even jobs with the same title aren't necessarily interchangeable. And it seems to me that what an employer is likely to do is to try to argue that the labor market should be defined, as broadly as possible, to argue that, there's no concentration because people can find another job in this market. And is that a significant issue, or do you think it will be a significant issue going forward, or not so much?
Yeah, it is a significant issue. You get the same issue in product markets. Is the market for, is the correct market all vehicles, or, just cars versus light trucks, or economy cars versus luxury cars? And there's that same incentive on the part of the seller to define the market as broadly as possible. And there are economic or econometric methods for figuring out the market definition. But as you point out, this is a more difficult problem in at least most labor markets. I mean, some labor markets, the people are pretty interchangeable. I mean, the jobs are designed that way. But in the case of doctors, I'm pretty sure, the proper market is going to be fairly narrow. It's not going to be doctors in general. It might be oncologists or pediatric oncologists, or senior versus junior pediatric oncologists, or there are all kinds of complications. And, there are limits to antitrust law, and those limits will probably play a larger role in labor market antitrust law than product market antitrust law. Another
distinction that seems to me to be important is sort of the issue of what I would call friction. Because with products, there's often, with most products at least, there's not a lot of friction involved for the consumer switching from one to another for various reasons. Sometimes it's just like clicking a different button on Amazon or on your phone or something like that. But with jobs, it's very different. And you talk about this in the book, that switching jobs can be fairly involved, and that can have a tendency, right, to keep people in jobs even when they're being underpaid, where in a reverse scenario, when if you feel like you're paying too much for a product, it's a lot easier to switch. And that can be a significant problem, right?
Yes, it can. And again, this is more a difference of degree rather than kind, but it is an important difference in degree, and is another problem with labor side antitrust litigation. But, in the product market side, there's a similar problem. I mean, for example, Amazon's a good example. It's very easy to switch among brands that are sold on Amazon, but it's kind of hard to switch from Amazon to whoever its competitor is. Once you have Amazon Prime, and, you think you're getting, and then they try to give you rewards and stuff like that. Personally, I found it very difficult to switch among credit cards and insurance companies. There are a lot of more complicated services where they get your data and they know a lot about you, and they kind of make things easy for you, so you don't want to switch. But that also gives them market power over you, which you may not be able to understand. Okay, but you're absolutely right in jobs, and particularly jobs that are complicated. And often, I think it's very common in the labor market that people over time engage in what economists call relationship-specific investments in their jobs. That is, they get to know the people there, they get to know the management and how things are done, the customs, the subtle unstated rules. The commute is convenient. Maybe they buy their house so that it's a convenient commute. All of these things can cause people to be stuck in a job. And, to the extent that causes people to be stuck in the job, then it's not illegal for the employer to suppress their wages relative to, what their value is for the firm. It's not good, but I think the consensus is there's not a whole lot that the that antitrust law can do about that, or maybe even the law generally. But again, these are things that in antitrust litigation can be handled. Economists can measure these costs. They can kind of subtract them out when they do their ultimate calculation of the damages that the workers sustain as a result of any anti-competitive conduct. So again, a big problem, but maybe one that can be handled in practice.
Earlier, you mentioned non-compete agreements. I want to talk about those because it seems to me you can make a legitimate case for them sometimes, but they can also be abused if they're used as kind of a way to suppress wages or lock people into jobs. And you mentioned the now I think almost infamous case of Jimmy John's, and I think you can maybe talk a little bit about the use and abuse of non-competes and how this all fits into what we've been talking about.
So a non-compete is an agreement between a worker and the employer, according to which after the worker leaves the job, the worker is not allowed to work for a competitor of the employer for a certain period of time within a defined geographic scope. So in the case of Jimmy John's, the workers in question were low-skill sandwich makers, who I think they called their sandwich artists. And the sandwich artists, when they started working for Jimmy John's, they signed a contract, which they may or may not have read, who knows, or they may or may not have understood. And the contract said, you're working for us, and when you leave Jimmy John's, you're not allowed to work for another business that makes sandwiches, basically. So maybe that's McDonald's, maybe that's Subway. Within, I forget the exact, I think it was like 6 miles or something like that. And again, I don't remember the exact amount of time. It may have been a year or 6 months or 2 years. That's kind of standard for non-competes. One of the twists here was that normally the non-compete just says you can't work within X miles of your current employer, but this one actually said you can't work within 6 miles or 10 miles of any Jimmy John's anywhere in the country. And there's John's, but that basically blotted out, most of the country. So, even if you were in New York and you're planning to move to California, you could find out that now that you live in San Francisco or LA, you can't work for any company that makes sandwiches, any business that makes sandwiches for several months. Now, non-competes, they've been around for hundreds of years. The traditional view of them is that they're illegal restraints of trade. That was true before antitrust law. That was true in the common law. Before the Sherman Act of 1890. And so courts would not enforce them if the courts thought they were excessively strict, which was never defined very clearly. But the basic understanding was, in certain circumstances, they made sense. So, for example, if you hire someone to be a salesman to sell your goods in a certain area and you give the salesman your proprietary customer list, so that he now knows this, he basically has access to this information that you built up over years. And if he quits and goes and works for your competitor, now, your competitor can basically use your investment in this customer list to take away your customers. And so the employer, were allowed to say to the salesperson, I'm going to hire you only if you agree to this non-compete. And even then, the courts would say the non-compete has to be tailored to the problem. So, if the customer list is going to depreciate over 6 months because people come and go, then your covenant not to compete can't be longer than 6 months. And if the area in which you sell these goods is just, this county, then the covenant not to compete can't extend to the entire state or the whole country. So, there's this whole background going on. And so, the basic idea is that an employer might have trade secrets, customer lists, other sort of proprietary information. And if its workers who learn that information can too easily go to a competitor, that will undermine the incentives of employers to invest in obtaining in this information in the first place. That's usually the defense of non-competes. Sometimes people also argue that it might protect an employer's investment in training workers, because if you spend a lot of money training your worker and then the worker just quits and goes and works for your competitor, you basically trained one of your competitor's workers, so people aren't going to want to do that either. Now, it sounds plausible. There's a lot of criticism of that because it's not entirely clear that you need non-competes to protect investments of this sort. In California, famously, non-competes are illegal, and yet California is the most innovative state in the country. But all that said, from an antitrust perspective, a non-compete is a restraint of trade. It basically says it's basically a way to prevent your competitor from hiring your employees. And so it should be at least subject to antitrust law. And while people have brought antitrust cases based on non-competes in the past, they always lose, virtually always lose, for a variety of reasons. Let me just say one more thing. Covenants not to compete have been in the news lately, not just because of Jimmy Johns, but because of the research of people like Evan Starr at the University of Maryland. And Starr has shown that, even if you believe the theory that non-competes might be useful way, appropriate way for an employer to protect proprietary information, they've gotten so common that it's hard to believe that that's really true. So I think he found that 40% of all workers have at one time or another been subject to a non-compete. And that includes a huge number of millions of low-skill workers who it's very hard to believe have any serious knowledge of true trade secrets. Certainly the sandwich workers at Jimmy John's didn't have any proprietary information. They knew how to make a sandwich, but that's not going to be a trade secret. So this does that employers are abusing non-competes. They're just sort of automatically putting them into contracts without thinking very much about whether it's appropriate, and that's going to reduce labor market mobility and reduce wages and raise prices.
Right. I wonder how much of a problem is the fact that in many of these agreements that employees sign, there's also a stipulation that they have to go to arbitration as opposed to taking things to the courts. I mean, that's fairly standard for a lot of these agreements. And so, do you see this as being an important issue or a problem in terms of getting these things, heard and moving forward on this issue?
Yeah, it's definitely a problem. It's part of a larger problem. Firms have been using arbitration to protect themselves from class actions, including antitrust class actions. And so, just to back up a little bit here, arbitration in principle is a good thing because, if you're a worker at Jimmy John's and they tell you you can't work for a competitor, you're not going to bring a lawsuit. A lawsuit is way too expensive. So at least in principle, if arbitration is available, arbitration can be extremely inexpensive. Of course, it depends. That might be a nice way for the worker and the employer to resolve their disputes. And so there's an important policy in the United States of promoting or protecting arbitration agreements. But over time, people have begun to realize that the reason why employers use arbitration agreements is that they can put in the arbitration agreement that you can't have class arbitration, nor and if you have to go to arbitration, you can't go to the courts. So if you can't go to the courts, you can't bring class actions. And so what people now believe, or many people believe, is that what's really going on is that the arbitration clause, whether it's in an employment contract or in a sales contract, is used to prevent private lawyers from bringing class actions. So if they bring a class action, the court will dismiss and say you've got to go to arbitration. And then you almost always cannot bring your class action in an arbitration. Your 10 million class members have to each individually do it, which is, if the amount at stake is relatively little, no one's going to do that. I'd like to see, some progress to rein in arbitration agreements when they're used in this way.
What about no poaching agreements? There are some similarities maybe between that and non-compete. Can you talk about those? Because we've heard about that in relation to some tech companies' agreements they've had, because it seems to me that if these agreements are informal or at least unwritten, they can be pretty difficult to demonstrate, to substantiate. And so could you talk about how important or how big of a issue these sort of agreements are in this area?
Yeah, I think they're quite important. So the tech case you're referring to was a lawsuit brought by the Justice Department against Google, Apple, and all the other big tech companies back in 2010, alleging that basically the CEOs of the tech companies, including people like Steve Jobs, had agreed among each other not to poach or hire away software engineers. So, for example, if you're at Google and there's a really great software engineer at Apple, you might try to hire that person, but under this agreement, you just can't. The result of which is that wages will be suppressed because the person at Apple can't say to Jobs, if you don't give me a raise, I'm going to go to Google, since Jobs knows that Google isn't going to hire that person. So no poaching agreements, in antitrust law, they're called horizontal agreements. They're relatively easy to litigate as long as you can prove an agreement. If companies just kind of independently adopt a policy of not trying to hire away from their competitors, that's lawful. And that's just called parallelism. And so the problem for plaintiffs, including the government and also workers, is they might get the sense that competitors are not hiring away workers, but they're not going to be able to stop that. They're not going to be able to bring a claim unless they actually have evidence of agreement. And that can sometimes be hard to get. Now, in practice, if you can show circumstantial evidence of various types, like, the CEOs, all met on July 1st, and then beginning on July 2nd, nobody was hired away from any other firm, whereas before they had, that might be enough to allow the court for the plaintiffs to then use discovery to actually compel the defendant to send them emails and so forth. And then you're going to hope that in the emails, you'll find the executives saying to each other, remember, we have this agreement not to poach each other's workers.
Yeah, it amazes me, I got to say. And you referenced a case where I believe there were emails. It was, I think, 2 academic medical centers and a no poaching agreement. And still the things that they actually put in these emails about, well, we can't hire them because it would cause wages to go up. It sort of startles me, I guess, the extent to which people would incriminate themselves in that way. But maybe that goes back to your point about employers just not really being worried about these suits being brought up in the first place.
Yeah, I mean, definitely. There were no such suits, right? So it may not have even have occurred, let's say, to the tech CEOs that they were breaking the law by making these agreements with each other. They were not lawyers. They were tech people. Now, if they were responsible people, they should have consulted their lawyers, their counsel. But I suspect the counsel would say, yeah, that's against the law, but, there's never been a lawsuit, period. They're not going to advise them to break the law, but they might let them know that it's not enforced. And so the Justice Department and the FTC, after the tech case, sent a notice around the human resources offices in the corporation saying, not only is this illegal, it's criminal. It's criminal to get together and agree not to poach each other's workers, so you better stop. And in the last year or so, the Justice Department has actually brought some indictments against executives who have allegedly used no poaching or wage fixing agreements. The case you're referring to was against Duke and the University of North Carolina. And it's an amazing case because basically you had a physician, I think she was a radiologist, I forget which place she was at, but basically she was at one of the places and she applied for a job at the other place and they said, you're terrific. The chair of the department said, you're terrific. We'd really like to hire you. And then a little while later, he sent her another email saying, I just learned from someone that we have this agreement between the 2 universities not to hire each other's workers. And then he goes on to explain, the reason was a while back ago, one university had poached various people from the other university and everybody was upset. So they entered into this agreement. Now, this is an academic and, typically academics are not very disciplined and may not even know this to say certain things. But once this got out, it was a pretty straightforward case. But, that's not going to get out very often. And that's a problem, right? So that's a problem for plaintiffs.
So do you think this is more a case of we need a culture change in that we have the laws already on the books to go after this illegal activity? It's just a matter of actually doing it. And if so, then, culture is notoriously difficult to change. How do you see this changing, or do you see this changing in a significant way?
I think it's partly, a culture change that's needed, and partly maybe a legal and institutional change. So yes, the law is already there, and in theory, it just has to be enforced. And I think the culture change has already begun. I mean, to their credit, the Justice Department and the FTC are taking seriously this academic research, and and also in light of the tech, the tech debacle, or the no poaching tech agreement. They realize there's a problem. They've been looking for cases, and they've been bringing cases, and the law is on their side. So I think making the cultural change is actually not that hard. I also think that economists, it's a little hard to tell at this point, but I think there are a group of labor economists who've done this research, and I think the more specialized antitrust economists are going to be sympathetic to it. So I do think the culture will change. I think the problem are the courts. The courts have been hostile, especially the Supreme Court, but the lower courts under the lead of the Supreme Court have been increasingly hostile to antitrust law on the product market side, any antitrust law over the last 40 or 50 years. And, so antitrust law has become narrower progressively. And I think it's going to be hard for courts to kind of reverse gears and recognize this new major type of litigation. I don't think they're going to say, workers cannot bring cases that's foreclosed by earlier precedent. But we've already seen a bunch of cases, and the judges are, I wouldn't say hostile, but they're skeptical. And there's confusion. We talked earlier about, what a labor market means. There's all kinds of confusion. There's problems about class actions. Judges have a lot of discretion. And so if they just feel like, this is not a serious case, they're going to be a little harder nosed about applying some of these strict rules. I think judges need to be nudged. And so I do think that legislation is appropriate. But I also think in the long term, one way or the other, I'm optimistic that this will be a major new type of antitrust litigation.
Well, on that optimistic note, we will close. And I just want to thank you very much for taking the time to talk with me today.
It was my pleasure. That was a lot of fun. Thank you for having me on.
That's it for today's show. We hope you like what you heard. If you'd like a second full-length Politics Guys episode every single week, as opposed to just these occasional interviews, you can get that by becoming a Patreon supporter. Supporters also get ad-free versions of every episode, as well as other good stuff. To get the details and to become a supporter, just go to patreon.com/politicsguys. And if you can't afford to become a supporter, email me at mike@politicsguys.com, and I will get you full access to that second episode every single week. And if being a monthly supporter is too much of a commitment, but you still like to help us out occasionally, you can do that too through PayPal. You'll find a link on our website, politicsguys.com/support. If you haven't already subscribed to the show, that is a big help, as well as leaving ratings and reviews, and especially sharing your favorite episodes on social media. That's a big deal to us. And if you've got a question, comment, correction, gripe, or whatever, you can reach us at mail@politicsguys.com. For more great discussions, check out our Bipartisan Politics subreddit. You'll find the URL in the show notes. We've also got a Facebook page. That's facebook.com/politicsguys page. And we're on Twitter @politicsguys. The executive producers of the Politics Guys are Bruce Johnson, Wilma Moreno, Andra Masker, Daniel Toe, and Chris Wilkerson. Today's show was produced by Michael Baranowski. We'll be back with a new show next week. We hope you'll join us.